SJC-13399, Commonwealth v. Elvio J. Marrero.
Thank you, Chief Justice Budd. Good morning, Chief Justice, Justices, and may it please the Court. My name is Ira Gant, and with the program, I represent Elvio Marrero, a man wrongfully convicted of murder 27 years ago. As a roadmap, I plan to use my time to address three reasons that show justice was not done here. First, the DNA evidence excluding the victim from Mr. Marrero's jacket would have removed an important piece of physical evidence that the Commonwealth relied on to argue that Mr. Marrero was in the victim's presence at the time of the killing, and then used that same evidence to corroborate a key Commonwealth witness who claimed to catch Mr. Marrero red-handed. Second, the exculpatory evidence that the police Commonwealth withheld by negligence or design would have significantly aided Mr. Marrero's defense. The Commonwealth compounded the prejudice to Mr. Marrero by presenting or relying on false or misleading testimony directly related to the evidence that it withheld. And then third and final, the motion judge's clear error. The judge wrongly applied a sufficiency of the evidence standard in analyzing the record here, and also relatedly but separately relied on a theory of evidence to resolve all of the evidence not argued by either part at trial. And on top of that, the judge failed to evaluate what this court has instructed judges to do in exactly these sort of cases, whether all of these things together might exist as some sort of confluence of factors, whether we have all...
Backwards for a minute?
Of course, Your Honor.
What about, why couldn't the judge, he could have gotten on that flight and still committed the murder?
Well,
why can't the judge look at the entire record and make that determination? Maybe the record doesn't support it, but why would it have to have been a...
For three reasons, I suppose, Your Honor. So first, because that's what the court has instructed trial judges to do, to not look at the evidence that's presented to them and say, is there still a way that the jury could have convicted? The question is, whether we're looking at the DNA, would this have been a real factor for the jury, or whether we're looking at the Brady issues, is there a rational basis for finding prejudice here? The question, the judge can certainly ask that question by looking at it, but can't lose sight of the fact that if this was not how the case was presented to the jury, and I suppose that's my second point, if that's not how the case was presented to the jury, as this court recently said in Tavares, what might have happened or might have been presented had these things actually been disclosed and had this evidence existed is speculative. And as this court instructed judges in both Cowles, Sullivan, I don't think in Cameron, but perhaps, this court should not go through and look at the evidence about what might have happened, wherein it should confine itself to asking what would have been a real factor for the jury, or what could the jury have done with this? Or really, what could Mr. Marrero have done had this Brady information been disclosed? Particularly to the Brady claim, this court's question at the end of it is, this court's actual standard that it has articulated is, can we be confident that had this evidence been disclosed, it would have had no impact on the jury?
What do we do? Sorry.
Oh, thank you. And I think there's a reason why your DNA argument was first in your brief. And, but let me take that aside and ask you about the travel agency and the flight record information. What I was struck on, albeit the late disclosure, was that there was a telephone number with, I think, a 413 area code in the record that was certainly available to defense counsel to call.
Correct.
That to me seems significant, and the judge honed in on that as well. Could you explain that to me? How that was saying that it's deprived because we have this kind of crooked travel agency, and we have the silent agreement that seems to be borne out by the fact that everybody stayed away from it, and the defendant, I mean, the defense attorney could have called the number on the list. And so explain that for me, please.
Sure, Your Honor. So I think there are a couple different ways to view that question and that evidence. One, the trial attorney did testify that it was her memory that's exactly what they did, that they called the phone number and they got nowhere with that. I also would argue that the court doesn't have to necessarily grapple with the judge's credibility determinations related to whether or not there was or was not a silent agreement, or whether or not he agreed of all of the steps that the trial attorney said that they took to investigate this in the middle of a trial in 1996 when no one had smartphones to do things like that during recesses. What the question comes down to under the Brady analysis is, what did the defense know, and what does the record show that the defense knew, and what could they have proved had this information been disclosed? Certainly, Mr. Marrero said he took the flight. Certainly, he knows that he made the reservation, but where the judge's error lies is in assuming that that somehow translates to him knowing what the phone number is to this travel agency.
What about what did he lose? What did he lose by not having it? The Paros nation was really going to go to whether records were kept. And the judge thinks that it's prudent for defense counsel to stay away from, Sunray, is that the name of the agency?
Correct.
The judges stay away from that drug dealing agency, and let's just not go there, which I guess feeds into the Justice Garciano's other point about was there a secret deal? So it's also in not having it.
Absolutely. I'm so glad you brought up Luis Porras, Justice Lowy. So first, to that point, I think that the fact that Luis Porras was called as a rebuttal witness to testify raises separate questions about whether there was this away from Sunray travel, whether the lest had be opened the door when the Commonwealth then specifically called the owner of Sunray Travel. Secondly, I wanted to just point out that the issues related to this travel agency with things related to drug dealing is all talking about a subclause of a line on a 26-page police report. Side, the Commonwealth presented three witnesses' testimony, all related to this issue. Luis Porras testified and repeatedly, the only Sunray travel in October, at the time the reservation was made, was Ilya Brito, who had just told the jury, I stopped working there on October 10th, and then testified, I have no records of reservations whatsoever. The trooper had just testified that we had looked into whether or not Elvio Marrero on October 14th and didn't find anything. And then was asked on cross, are you familiar with this phone number that's on the flight record? Now, I agree.
But doesn't it show that the E. Marrero isn't one of the 7 people in the white paper? It's got to be this defendant because it's made out of Springfield.
I didn't catch the first part of your question, Justice.
Because the government says, well, there are 7 E. Marreros in New York City. Mm-hmm. Could have been one of them.
Well, that's exactly what the government did.
Right, but then we get the record that says, oh, no, this was made out of Springfield.
Correct, Your Honor. So that's exactly what the government did. That was the third witness that they put on, was this phone book record keeper to say there are 26 E. Marreros in the Bronx. It could have been one of them. But what they didn't disclose, and this gets to your question, Justice Lowy, what could Mr. Marrero have done with this? What it didn't disclose was that the police had discovered before that they did link the phone number and that they were aware that the phone number was 413 was linked to this Holyoke travel agency. And next to Luis Porras' name in their records, which the trooper admitted at the motion hearing, was can confirm reservation made, directly contradicting what Mr. Porras testified to. And that Ada Quiles was the ADA travel agent who made the reservation.
But I guess,
Yes, Your Honor.
The judge had an evidentiary hearing on this Brady issue, right?
Correct.
Okay. And the judge found the prosecutor to be credible and the defense counsel not to be, right, on this issue?
Not exactly, Your Honor. So the judge did discredit the defense trial counsel about the steps that they took to do their investigation in the middle of the trial. That is what he
and found the
specifically
prosecutor to be credible that this was, the Sunray travel was an issue that both sides decided to stay away from.
That is what the judge found.
So that there was a strategic decision to not pursue any more detail on the PNR.
Whether this court finds that there's a rational basis to find that prejudice existed from the Commonwealth's failure to disclose, or that there was an ineffective assistance of counsel based on the trial counsel's strategic decision. Either way, what we get to here is that Mr. Marrero was deprived of substantial ground of defense to present this information to the jury, because had he had this information or put forth this information, whichever way you come at this, one, the Commonwealth may have chosen not to call Luis Porras in the first place to go on and testify that I have no records of reservations.
Isn't your
and I have no-
ineffective assistance better than your other? I mean, isn't there plenty of evidence that he's a drug dealer in this case?
It was
So I don't
throughout
quite
the trial.
understand why. I see your ineffective assistance argument as being more persuasive than, and the judge sort of rejects that as a strategic decision, right? But it seems kind of odd, given there's so much evidence that you're a dealer, and he's being charged for murder, so his drug dealing is not something, it's all over the case. So why not bring in the sunray stuff that shows he's the guy supposedly on the plane, and it buttons that issue up for you, right?
The trial prosecutor said in the motions in limine to introduce all of the evidence about the drug dealing, that Mr. Marrero's drug dealing and the drug dealing going on in this case is inescapable. And that bore out at the motion hearing as well, that it is littered throughout the trial. You can't turn to a day of the trial testimony, drug dealing. That is 100% the case.
Can you, there is a reason, as Justice Gaziano alluded to, why number one on your arguments is the DNA. And that,
About the DNA evidence, Your Honor? Absolutely.
and
Thank you.
maybe tie it to the, if it can be, to Johnson and the testimony about Johnson and a potential third-party culprit.
Absolutely. Well, I think that the DNA, one of the reasons that it was first was because I think that looking at the case through the DNA lens can see exactly how this all shatters across the case. So your question, Justice Lowy, and to your question earlier, Justice Gaziano, the witness that testified that she saw Mr. Marrero at around 2 a.m. with blood on his hands is the only witness that is not somewhat, or not entirely contradicted by the flight records. So your questions as to whether or not, couldn't the judge say, well, how could the jury have looked at this evidence? If this case was retried, I'm sure the Commonwealth may make that argument, or could make that argument, but for the DNA evidence. So the jury was told this testimony and the positive blood test in Mr. Marrero's jacket. The jacket was held up or pointed to, and the trial prosecutor said, you heard the chemist that they're tested positive in each and every quadrant on the inside of the jacket that was tested. You heard that blood was leading away from the victim, blood was on the front door. Isn't that all consistent with Mr. Marrero with bloody hands putting on his jacket and then leaving?
Two different things, though. We
Yes,
have the blood trail is the dreaded canine grouping test.
Correct.
The jacket is a cult blood that Morehouse says she sees. So if and that's what the DA honed in on. So it's like out the blood scene, the crime scene blood, and the blood trail versus the jacket, because they're two different tests as well. Right.
I agree, Your Honor. I'm sorry, I don't know if you finished your
No,
question.
that's the observation. I think it's if you could tease that out as well.
I agree that there are two different tests that come with two different results prior to trial and then of course now. But the point is that the Commonwealth, in its closing to the argument, drew them all together to say to the jury, isn't this all consistent? Isn't this proof that Mr. Marrero is guilty because it's some jacket, fled the scene, and then Lynn Morehouse sees him with bloody hands and essentially
That's
caught him
number
red-handed?
two, though. Number one, you got to, I agree, you got to separate it out. The blood trail, I mean, whose blood do you expect that? Isn't that going to be the victim's blood?
Well, of course the blood is going to be the victim's, but that's not what, of course, I think that is the reasonable inference that one can make, the jury, or not what was argued at trial. I think that the DNA evidence, again, linking it to the third-party culprit and linking it to the Brady issues and everything else, is any way that you want to cut it. The DNA at the crime scene is not Mr. Marrero's, it's not the victim's. And if there was Mr. Marrero's DNA at the crime scene, you would expect to find his blood and DNA all over the jacket. That's also not there. The victim's DNA all over the find his DNA all over the jacket, which is exactly what the Commonwealth argued to the jury.
Well, but the jacket's found how many weeks later? The jacket's like months later, right?
The jacket was on Mr. Marrero when he was arrested. But I would urge this court that that same delay in collection of evidence existed in Cowles, existed in Sullivan, and also existed in Cameron, where they're related to underwear that a person wore for days before they were turned over to the police. And so while that certainly goes to weight, and again, if this argue that, that's not the end of the analysis for this court, because that same chain of custody weight question existed at the time of trial, when they put forth the positive blood results to the jury.
And argued that the results indicated was correct.
Correct. So that's the two parts here.
Let me ask you on this, again, the prohibited could not exclude testimony. I know we have DNA cases involving that language. Do we have involved in the blood grouping test that we use pre-DNA, where they use a could not exclude for an include, essentially?
I would have to go back and read the record, but I think we detailed it in our reply brief. But my memory is that from the Sullivan case involved both positive testing and blood grouping, and the Cowles case involved the semen, but not the blood itself. But what I would note there is, in the Commonwealth's brief, they sort of suggest that this blood grouping is the least discerning test.
Well, we don't know. There's no Matai stats.
That there's been one of the tests that they did among several others. What we now know, not the victim's DNA, not Mr. Marrero's DNA at the crime scene. The central crucial point is that what the Commonwealth used to put Mr. Marrero in the apartment in front of the victim at the time of the killing is gone. They could not argue that at a new trial. They could, if that evidence had been available in 1996, they could not have made that argument. And that is a real factor for the jury as they're trying to assess the central contested issue here. Was Mr. Marrero the murderer? Was he seen in Greenfield on October 14th?
Really, were DNA evidence that you couldn't tell who it was and it was inconclusive, you couldn't argue that today.
Correct. Since this court's holdings in Cameron, no, they could not say that without the defense opening the dual analysis. If there are no further questions, I just wanted to reiterate that missing from the judge's analysis of the DNA and from the Brady is how all these things would have worked together. So on top of the fact that the DNA would have been a real factor for the jury evidence that was presented, whereas the evidence that wasn't disclosed, and the same is true otherwise. Other than that, we'll rest on.
So a statement of the defendant to Herrera, maybe, that he did it.
Mm-hmm.
Yes, Mr. Herrera did claim that
They had in different stories.
Correct. Even though Mr. Herrera could not remember what day that conversation occurred, or if it even occurred on the same day, that also would be contradicted by the flight record because Mr. Marrero could not have been given a ride to Holyoke while over the Atlantic Ocean. Thank you, Your Honors, and we'll rest on our brief.
Thank you. Okay, Attorney Lynch.
Ooh, just barely. Good morning, Your Honors. May it please the Court, Assistant District Attorney Bethany Lynch for the Commonwealth. If the Court is agreeable, I will start with the DNA issue. The DNA issue in this case, I would suggest, was not as important or as the defendant is making it seem now.
I'll tell you the process I use. I go to the closing argument, and I see whether or not the prosecutor argued that point to see if evidence is important. We go to the closing argument in this case, and there's a silent witness here and talks about the DNA evidence.
Well, she talks about the occult blood in the jacket. I agree to that, and I agree that that has been, in a way, partially disproven by the current DNA standard. Or out that the DNA testing that was done in this case that we now have, it was DNA. There was no indication whether it was DNA from occult blood or from just the inside of the jacket. It came back to the defendant, but it came back partial with a mixture.
At trial, we have a chemist saying
that there was occult blood, and I don't think
the occult blood in it, and we have Morehouse saying he was a bloody mess and he was wearing that jacket, and the DA says, aha, put the jacket on.
I agree, but I would,
The problem.
it is a problem. In a way, it's a problem, because I don't agree that this DNA testing completely throws that evidence out the window.
Is that the standard?
Yeah, it does.
No, it's not the standard, but I'm saying that the DNA testing that has
Isn't
been
it just
presented
that
to the
whether or not
court,
it would have been a real factor?
that it would have been a factor that the defendant's own DNA was inside his jacket versus the fact that there was testimony that there was occult blood with no result. And we still have no result as far as knowing whether the defendant's DNA was the source of that occult blood.
Well, so just remind me, what is the new evidence?
The new evidence is that there is a partial DNA profile from the inside sleeves of the defendant's jacket. There's a it's a mixture. There's a major and a minor contributor. The major contributor is the defendant. So the defendant's DNA is inside his own jacket.
Right, big deal. So what about the minor contributor?
The minor can be linked to no one.
Okay.
So my point is that because it can't be linked to anyone, it does not disprove that it was the victim's blood.
You asked the jury to draw the inference.
We did, based on the evidence that we had at the time, and I'm
Exactly,
saying
and I
that this
don't-
DNA evidence doesn't entirely undercut that evidence. And so, but.
Again, that's not the cut, right?
No, but I would suggest that the standard is that it has to make a meaningful difference, and the fact that it doesn't disprove that it is the victim's blood means that it is less of an important factor than the defendant is currently arguing that it is completely
No one
exculpatory.
realized that I did my blood grouping test. This is all pre-DNA.
Mm-hmm.
And she says it's this AK1 protein, whatever the blood grouping test is. And could be the defendant, could be the victim.
Because they,
Exactly.
the
Well,
other,
but she says the magic words, which we've said are problematic, cannot exclude the defendant.
I believe that she says that that it would be a match to either. I
Right,
don't know that
cannot
it
exclude
said,
the defendant.
because it matches both of them. And
If I'm a lay juror and I say, geez, probably that, maybe the defendant's blood grouping or his blood marker is on that blood trail.
but all of the other blood did exclude the defendant.
Right.
And anything that was an exclusionary result excluded the defendant in favor of the victim. Or was excluded the defendant, and we don't know if it was victim blood. So there were where the victim and the defendant shared the marker, which was the only marker that resulted in a result, and that they match on that marker was instructed to the jury.
That's why we said in Matai, you can't the significance of this evidence, even in
Yes.
DNA.
Yes,
Never mind blood grouping, which is
Yes,
not
in
that
today's,
discerning.
today, I don't know that this would not come in today. But at the time, it did. And at the time, it was given to the jury as this places the defendant at the scene because of these blood drops, because he can't be excluded. That was not argued. The only reasonable inference from that result is that because all of the other blood in this incredibly bloody scene belonged to someone specifically, to the exclusion of someone else, belonged to the victim, this was also victim blood. That was really the only inference that could be made, and it wasn't argued that it was defendant blood at the scene.
Can you address this confluence argument, the Rosario, Bresci, where we take the DNA evidence and we also take into account the Brady violations in the ticketing information?
Yes, I would, first of all, just to address the Brady violations quickly, I would make and more oversights, obviously, and also the phone record, anything on the PNR, that I would point out very specifically, that was defendant discovery. The defendant gave that discovery to us. We didn't have it and neglect to explain it to him. Middle of the trial, and is now faulting us for not explaining his own evidence to him. So I would suggest that
The fault was with regard to the investigation that was then thereafter undertaken and not disclosing the results of that investigation.
the investigation as to the phone number,
No,
Or
the
as to-
entire, I thought that the prosecutor was surprised. It was a real gut punch
She was-
to
yes.
her case, and so she asked one of the to run it down, and then he obtained a bunch of information that was then thereafter not disclosed to the
Right,
defendant.
Yes.
The police notes.
Yes, the police notes, but the police notes having to do with the phone number and the ADA, those notes were of running down the notations on the PNR and on the had, and that the defendant provided to us. So it's, at this point, faulting the Commonwealth for not going out and looking for exculpatory information on his own evidence to give to him and explain to him.
That's not the standard, though. So if the defendant's the source, right? You
Yes.
get information from the defendant. And this is all a trial. I
Exactly.
get that, haven't been there, all right? You say, run this down, or the ADA says, run this down. The trooper runs it down, gets some information which is helpful to the defense, by definition, Brady, and then does, because the source started with the defendant, once you get helpful information, you have an obligation to turn it over under Brady.
I would agree that there would be an obligation. I think, first of all, it would have to be recognized as an obligation to turn over something that we would presume that they would not already know, having been the source and having access and made these.
You don't tell the
but-
ADAs below, the ones that you
No.
don't tell them, hey, they
No, and
probably
I-
have it, so don't worry about it.
Right, and I'm not arguing, and I'm hoping I'm not coming across exactly like this. I'm not arguing that there was no obligation to turn anything over. I'm saying that at this point, we got the information from the defendant, and it was mid-trial. We do know that we had this information, and that it could be slightly exculpatory if the defendant didn't know the full phone number.
I guess, back on the confluence point, and I'm sympathetic to you on the Brady issue, particularly, it just talks about this is lightning speed at trial, but ineffectiveness, I can't get around that. Here we got the punch in the gut evidence that Marrero is on this plane. He's left town at a time that's inconsistent with 3 of the witnesses. Is there. We know he's a drug dealer. The whole case is about his drug dealing, so it makes no sense not to pin that down. Don't, when we combine the evidence on the blood with the fact that this guy is about his passport is on the plane, make this a do-over? I'm not used to this much. I've been doing this a long time. This is a lot of evidence that raises questions about whether we got the right guy here.
But I would also suggest that almost all the phone number and the ADA and the opening the door to the international drug trafficking that was supposedly taking place.
Who cares?
All of
He's
that
on
was
trial
before the
for
jury.
murder, and
But
he's a
all of
drug
that-
dealer.
I'm sorry.
He's on trial for murder. Everyone knows he's a drug dealer. Both sides are putting in evidence that the culprits are all part of this drug dealing scheme. Buyers, sellers, blankety blank. Isn't there don't we? And he's got to get to New York at a time that wipes out 3 of the witnesses, except for the one who testifies about the blood on the coat, right? And even then, it's like a dash to New York to make the timing, right?
It would be.
And the prosecutor is saying it's a different Marrero on the plane, and it looks like it is the Marrero, or at least somebody with his passport using his travel agent. It's really hard.
I think the part that makes it less difficult for me is the fact that all of that evidence, with the exception of the phone number and who Ada was already in front of the jury. All of the evidence about the defendant's passport, about the time, about when the reservation had to be made, how you had to check in on the plane. The jury had all that information.
That the defendant's travel agent is the one who, that wasn't before the jury, right? Because otherwise this stuff about Marrero in the phone books would have been ridiculous.
Well,
right?
we know what was before the jury. Mr. Marrero used this particular travel agency to travel routinely. He was there almost daily, and that he was very familiar with the employees who worked there. And so that was in front of the jury, that this was the travel agency that he missed, that he
He
used.
also had Poros' testimony.
And he testified that he doesn't keep records of reservations where the ticket is not paid for at his own office. And that is corroborated by the fact that the PNR itself says that the ticket was paid for at the, so he testified that he did not keep records of reservations that were made but not paid for through his agency.
Let me sort of get back to the big picture so that you can, because of what there's concerns here, as everybody has mentioned. The alibi gets just blown asunder because you've got these witnesses testifying about seeing him and wanting a ride and making all sorts of inculpatory statements. So the alibi is just blown up, and he has potential corroboration of the alibi. And it's not the strongest case point in the world, but you got motive, and he's got a history as well that's not that different from the defendant. So on the other side, what do you have that this is not enough for a reversal?
That it's not enough. I think that the key point is that all of the evidence that you just mentioned was presented to the jury, and the jury, their prerogative to do, credited the testimony of the witnesses and did not credit the alibi. And so what we have now in this motion for new trial is pieces of evidence that could have been added, but this court, as the lower court did, as the trial court did, has to look at that and determine whether or not those small pieces of evidence, a partial phone number, versus inferentially connected based on all of the connections that Mr. Marrero had to Sunray Travel that were in front of the jury in terms of how he used it. The travel agency to travel.
I want to make sure I understand your argument, though, and give you the best offer. You know, that the DNA is permeating the case. It's giving the jurors that corroboration comfort. You've got an alibi that's going to be really hard to work with these other witnesses. I got to get to Chicopee right away, and all of that. And you got Johnson, not even close to as much as evidence as the defendant, but you got Johnson as a potential third-party culprit. Mm-hmm. That's on as we're trying to look at how much the missing pieces matter here. Mm-hmm. What do we balance that against?
Okay, well, you do balance it against the witnesses who placed him there. In the general vicinity, you have one witness who was the last person to see the victim alive and said that at midnight he left the defendant in the victim's house. We know the defendant had a key to the victim's house. We know that he is known to hide his stash in various places, and when it is stolen, he gets very upset and he accuses the people that he deals drugs to of stealing it. We have a history of him attacking people from behind with boards and threatening people with knives and threatening to tie people up, all of which is what happened to this particular victim. We have his fingerprint at the crime scene on a chair that's in close proximity to the victim. We do have him with bloody hands. We have him nervously as soon as humanly possible. We have him paying twice as much as normal to leave. He usually pays a rock of crack cocaine for a ride to Chicopee. He paid gas money and 2 rocks just to get out of town quicker, I would say.
But by the way, that Chicopee description is warning, right?
It is.
And the description of him in the house is that they're amicable, right? That the description of him at night is they're getting along, right?
Yes, that he's sleeping, but we do know that that there was some suspicion thrown on the victim as a person who had recently stolen a stash from him.
To get to New York to be on a 5 o'clock plane, that I take it that means all those witnesses have got to have the time wrong, right?
They do, and
That's possible?
I would suggest it is possible, and I would suggest that is what the motion judge found, is that the witnesses who were discussing this didn't link it to anything in particular. They didn't link it to a clock, they didn't link it to anything, and these were drug addicts who there was evidence were not necessarily up on all the details. So the trial judge, absence of, I looked at my watch and it said it was this time, they could be off on the time. He could have gotten to New York. He also did confess to the crime. I think that's important too. He confessed to Herrera, and then when he returned, he fled the country.
The confession to Herrera was on
in mid-October.
October at a time where he would have been in the Dominican Republic?
Well, I mean, he had been in the Dominican Republic on the 14th. I would suggest that, or the 15th, if he like, I think mid-October leaves enough room that he could have talked to Herrera before he left the country. There's no doubt that he left the country. I don't know when.
It's also his
And-
conduct when he gets back.
And then there's his conduct, yes, he lies to the police from Greenfield. He also left the country for a lot longer period of time than he usually did. He would go to the Dominican Republic for a few days and return, and he did that on several occasions. This time he left in October and didn't return till February. He inculpatory evidence that the jury heard and weighed. The jury also saw the witnesses testify, and again, the jury credited the witnesses and did not credit the alibi. And the small bits of information about a phone number, which ugly drawn a line, but not I would suggest it wasn't necessary because there was enough inferentially to argue that that was Sunray Travel. And I believe that the defense attorney did link them in his closing argument, saying it was a 413. Of course, the phone book was a ridiculous avenue to go down. If the court will indulge me for 1 second, there's one other issue where the defense accused the Commonwealth of presenting false evidence or of not correcting false evidence to the jury. And I would just like to point out that if the court were to read the passage in question, the attorney for the defendant asked Trooper Hart out of the blue. It was not connected to anything. There was no context. They said, "Are you familiar with an exchange in Western Massachusetts that is 413-532?" It was not a full phone number. It was a partial phone number. They did not show him the PNR. They didn't connect it to the PNR. They said, "Do you know this phone number?" And he said, "Not off the top of my head." And I would suggest to you that that is not a false statement. That interviewed numerous people in the 413 area code having to do with this case, and it answered, "Not off the top of my head." So there was nothing there to correct. There was nothing incorrect. There was nothing misleading about that. This was also not the trooper who was chasing down Officer Sergeant Von Flatern is the one who was tracing it down. Now, I know that they're imputed to have knowledge of the other officers, but this was an officer sitting on the stand, a trooper on the stand, saying, "Off the top of my head, I don't know what that number is." The defense issue. So to couch this in terms of intentional or misleading testimony or false testimony that the Commonwealth then failed, the ADA then failed to correct, I would suggest is misleading to this court and should not be, that you would read that very carefully to see whether or not it appears to be false or misleading.
Okay.
If the court has no further questions, I'll rest on my brief.